Major breaking news. We have a very interesting development in the United States versus Rahimi case before the United States Supreme Court. We have a decision, that's right, by Judge James Ho, the author of a powerful concurrence in the Rahimi case when that case was in the Court of Appeals. Now that case, of course, is before the Supreme Court. There were a lot of arguments in briefing, a lot of questions at oral argument just a couple weeks ago in the Rahimi case. And guess what just happened? Judge James Ho has apparently issued in a new case a specific set of rejoinders and comments about the Supreme Court case of Rahimi, basically defending the decision that Judge Ho made in the Rahimi case when it was down below. Let's talk all about it when we get back. You're not going to want to miss 1 second of this. Hey folks, I'm Mark Smith, host of the Four Box of Diner, proud American gun owner, constitutional attorney, member of the United States Supreme Court Bar, and author of Disarmed, What the Ukraine War Teaches Americans About the Right to Bear Arms. All right, folks, so major development in the United States versus Rahimi case before the Supreme Court, although this event I'm about to describe did not occur directly in the U.S. Supreme Court. Quite interesting, a new development. Specifically, as you may recall, in the Rahimi case, it arose out of a decision by the United States Court of Appeals for the Fifth Circuit out of New Orleans, Louisiana. One of the critical parts of that was a concurring opinion by Judge James Ho, who is on the short list to be a Supreme Court justice if we can ever get another Republican president elected. So what happened just now is, as you recall, over the last couple months, there's been a lot of briefing, meaning major amicus briefs and party briefs going back and forth in the Rahimi case before the U.S. Supreme Court, and a huge 90-minute oral argument just a couple weeks ago between the Solicitor General's office on the one hand and Matthew Wright, the lawyer for Mr. Zaki Rahimi, on the other hand. Now, what has just occurred is very interesting. In a decision in the United States, in a case called the United States versus Kersey, a 3-0 decision by the Fifth Circuit Court of Appeals has concluded that the constitutional rights of an accused criminal defendant have been violated because he was not given his adequate Sixth Amendment rights. That Sixth Amendment rights, specifically the Sixth Amendment, provides, among other things, that in a criminal prosecution, you have a right to a speedy trial, to an impartial jury, among other things. And specific to this case, you have the right to confront witnesses who testify against you. Now, without getting into the details, in this case of United States versus Kersey, Mr. Kersey had been convicted of a crime. He served 5 years in prison, I believe, and he was sentenced to 5 years of supervised release, which said he could stay out of prison provided that he behaved and did not violate any of the conditions. Well, it turns out there were allegations that he violated some of the conditions of his supervised release, probation or whatever you want to call it, and he was basically found to have violated these conditions, but he never had the opportunity to cross-examine any witnesses because the evidence that was entered against him was all on the paper with some audio recordings and whatnot. So the bottom line is he immediately sought an emergency appeal to the Fifth Circuit Court of Appeals saying that he was denied his Sixth Amendment right and he should not go back to prison because the judge was said, hey, we find you guilty of violating your conditions of supervised release. Now we're going to send you back to prison for 6 months because you did so. But he says, hey, you didn't prove the case against me. I was denied my Sixth Amendment rights because I had no opportunity to cross-examine people or anything along those lines, and that's not appropriate. Well, it turns out the Fifth Circuit in a 3-0 decision has just agreed with Mr. Kersey. So they basically said that, he was denied his Sixth Amendment right to confront witnesses because no witnesses were called. It was a bunch of documents that was entered, but no opportunity to cross-examine anyone to figure out who's telling the truth or who did what or when. So as a consequence, the Fifth Circuit 3-0 sent this back to the district court to have a full-blown hearing with witnesses and cross-examination to see whether or not Mr. Kersey violated the conditions of his supervised release. If he did so, he'll have to go back to prison. If he didn't, then he can stay free. That's the concept. But what's very interesting to us, we in the Second Amendment community, is a concurring decision, a concurring opinion in this United States versus Kersey case that just came out. It was written by none other than Judge James Ho, who, as you may recall, wrote a very powerful decision, a very powerful concurrence in the Rahimi case that basically said that if you are too dangerous to be out on the street with a gun, you are too dangerous to be out on the street, period. And if that's the case, then we should give you full-blown due process and a full-blown criminal trial. We should convict you of a crime and we should put you in prison, which is where people that can't behave and are violent thugs and misbehave in society belong, not to play along with these civil procedural games that we see under 18 U.S.C. 922 G8, which is, you know, that if you're subject to a rubber-stamped domestic violence restraining order, then guess what? You lose your gun rights during the duration of a restraining order, even if the restraining order goes on forever. So basically, Judge Ho specifically said that that is outrageous. It violates the Second Amendment 6 ways to Sunday, and wrote a powerful concurrence in addition to the majority opinion in the Rahimi case, and that is what is up on appeal before the U.S. Supreme Court. Now that we've just had oral arguments in the Rahimi case and a bunch of briefing back and forth and a bunch of arguments back and forth, it turns out that Judge Ho is using this opportunity in this Kersey case that speaks to the Sixth Amendment right, which is kind of a version of a due process concept, to speak directly to the U.S. Supreme Court and tried to get the last word in about why his decision in the Rahimi case in the Fifth Circuit was absolutely correct. So specifically, let me tell you what Judge Ho writes. He starts off by saying this, and this is his concurring opinion. I'll put a link to it down below. Judge Ho writes this, quoting and citing to the Rahimi case in the Fifth Circuit. He writes, quote, "Violent criminals should be prosecuted, convicted, disarmed, and incarcerated," citing to Rahimi, Fifth Circuit. "But we do not presume," this is powerful language, "but we do not presume that citizens are dangerous criminals. We presume they are innocent. And to overcome that presumption, we require more than just notice and a hearing." Notice and a hearing? That's the language in 18 U.S.C. 922 G8. Not a coincidence, trust me. "We require more than just notice and a hearing. We afford the accused, with the assistance of counsel, and a meaningful opportunity to present evidence and to confront adverse witnesses. We impose a robust burden of proof on the government, and when in doubt, we err on the side of liberty. These principles inform our decision today. I accordingly, therefore, concur." Judge Ho continues. "The district court found Jeffrey Kersey guilty of assaulting his girlfriend, among other offenses, and sentenced him accordingly. But it did so without affording him the right to confront and cross-examine adverse witnesses. So the majority here, including myself, i.e. Judge Ho, vacates his sentence despite meaningful evidence that he is a dangerous criminal." Judge Ho continues. "I agree and therefore I concur. However, I write separately to observe that the court grants relief not because it is insensitive to domestic violence or the safety of Kersey's girlfriend, but because it is sensitive to the constitutional rights of the accused." Powerful language. You hear what just happened there? Very important. "You are presumed innocent until proven otherwise." He goes on again. Judge Ho, specifically, "We are not being insensitive to domestic violence or the safety of Kersey's girlfriend, but because it is sensitive to the constitutional rights of the accused." You see there? He's responded to Merrick Garland's argument and the Department of Justice argument that says that we need to bend over backwards and ignore all constitutional guarantees, including the Second Amendment, when we're dealing with domestic violence. But guess what? You'll see that it turns out major issues with this case of Kersey, and it speaks to the Rahimi case. So specifically, Judge Ho continues on to say, "In respect to today's decision, the decision today reminds me of our decision in Rahimi." He's linking this to Rahimi. He's basically saying, "Dear Supreme Court, read this. I want to remind you of a few things before you issue your decision in the Rahimi case at the Supreme Court." Judge Ho writes, "We initially upheld Rahimi's conviction, but we later reversed ourselves in light of Nyserpa versus Bruin. Bruin involves the Second Amendment, not a criminal procedure. But Bruin admonishes us not to treat the Second Amendment as a second-class right, subject to an entirely different body of rules than the other Bill of Rights guarantees. And the court, meaning the Supreme Court, has construed other provisions like the First Amendment to require procedural safeguards to protect substantive rights like the freedom of speech." Judge Ho continues talking about Rahimi. This is functioning as a surreply, as an argument to the U.S. Supreme Court, addressing some of the things you heard in the writings and the oral argument. Judge Ho is specifically speaking to the Supreme Court, but he's using this United States versus Kersey decision and his concurrence to accomplish that mission. This is what he continues on to write. Quote, "So in Rahimi, we followed the court's directives and conceptualized Bruin not as a substantive right of dangerous criminals to run armed and free, but as a procedural protection for those subject to disarmament on suspicion of criminal activity. We applied the history and tradition test articulated in Bruin and found that the only historical analogs relevant to Mr. Rahimi involved the use of the criminal justice system, not civil protective orders to disarm dangerous criminals. He then goes on to write, we conclude that to survive Bruin, the use of civil protective orders to disarm citizens must presumably, and at a minimum, approximate the protections afforded to those accused of a crime. Very good language for us that Judge Ho is talking about. He then continues on to say, and that's what was missing in Rahimi. Mr. Rahimi was suspected of other criminal conduct, but he was not a convicted felon. Yes, Mr. Rahimi was subject to a civil protective order, which was entered prior to those other suspected crimes. And yes, Mr. Rahimi received notice and opportunity for a hearing, but the order was entered, the order, meaning the domestic violence restraining order, was entered without counsel or other safeguards. In fact, it did not even indicate a formal hearing or a judicial record, nor did it apply a meaningful presumption of innocence or a robust burden of proof. So yes, Mr. Rahimi agreed to the order, but without any of the protections we typically provide to the accused to ensure that they have meaningfully protected their rights. So we vacated the Rahimi decision, and the lack of adequate procedural safeguards rendered the statute in Rahimi deficient on its face, and for the same reasons, the court right here and right now, is right to grant relief to Mr. Kersey in this case here. Now, it gets even better in certain respects. Judge Ho then goes on to make a critical point to the Supreme Court through this Kersey decision. He reminds a critical fact to the court. Here's what he writes. This case of Kersey further parallels the Rahimi case in another way. In granting relief to Mr. Kersey, our court today acknowledges the unfortunate fact that people sometimes allege domestic violence but then later recant. Period, close quote. So here you have a powerful reminder by Judge Ho to the Supreme Court that, hey, a lot of people say a lot of things in affidavit and they will refuse to testify under oath when, you call them. And that's what happened with Mr. Kersey. That here's a guy who is really convicted of violating his conditions of supervised release without having to confront or having the opportunity to confront witnesses. They just submitted affidavits and said, here you go, Judge, it's good enough. And the judge accepted it. And the Fifth Circuit says, under the Sixth Amendment, he has the right to confront witnesses against him, cross-examine those witnesses. If you don't provide those witnesses, you can't cross-examine them. You can't use that evidence because under the Sixth Amendment, he's entitled to the right to confront. Now, this is also quite interesting, and I'll just sum up with this. Judge Ho specifically is speaking to the Supreme Court by pointing out all the different times that the U.S. Supreme Court has basically sided with dangerous criminal types because the system did not afford them adequate due process or other procedural protections. This is what Judge Ho writes. This is a clear message to the U.S. Supreme Court in the Rahimi case. And we'll see, and my guess is the Supreme Court's going to mention this when they issue their Rahimi decision, whenever that may be. This is what Judge Ho writes to the Supreme Court, using the Kersey case as his tool to get there. He writes, quote, the Supreme Court has repeatedly granted relief to dangerous criminals out of concern about the procedures used to determine their dangerousness. He then cites to many cases involving kidnapping and rape, sexual abuse of a child, assault and attempted murder, armed career criminal, and also burglary and so on and so on. He cites these cases by name and number. Then he goes on to say, in none of these cases did the United States Supreme Court decline to uphold constitutional safeguards just because the defendant was credibly accused of a dangerous crime. If government must turn square corners, and this is powerful, listen to what I'm about to say. This is what Judge Ho writes, quote, if government must turn square corners when it comes to the removal of illegal aliens, signed to a case in 2021 Supreme Court case, surely it must do the same when it comes to the basic rights of our own citizens. I accordingly concur. Period, close quote. Judge James Ho, potential future Supreme Court Justice, powerful concurrence in this Kersey case. But the reality is, even though he wrote this concurrence in the United States versus Kersey case that just got released, dealing with the Sixth Amendment right to cross-examine and confront witnesses against you, the reality is that concurrence is not written for you. It's not written for me. He wrote that concurrence as a functional reply to the United States Supreme Court, and those justices are going to read this, and they are going to confront this or address this or something along those lines. You can bet your bottom dollar. You shouldn't bet your bottom dollar, but you get the metaphor. You can bet that the U.S. Supreme Court is going to read this very carefully, and whether they cite to it or not, only time will tell. But I suspect there's a very good chance that that concurrence here in Kersey may find its way into one of the Supreme Court opinions or dissents or concurrences in the United States versus Rahimi case. But whatever happens ultimately in the writing, these views of Judge Ho are undeniably going to be read by the Supreme Court justices and their clerks in the context of deciding the Rahimi case. So it will be very interesting to see how this plays out. It's very interesting to see that Judge Ho went out of his way, as I see it, to address some of the concerns raised in the Rahimi case, even though this case is called the United States versus Kersey, and it's in the Fifth Circuit Court of Appeals. So, all right, folks, hope you learned a little bit something here today. I'll put a link to the decision down below. Don't forget to follow me on X at 4Boxes Diner, and we will see you again soon here at the 4Boxes Diner.
Orders up. Table 2A.